The main reason, like you were saying, is if a client is retained, decided to file a bankruptcy case, maybe put their $100 down, but it's going to take, 60, 90 days, maybe longer to actually get everything paid up and the petition prepared to be filed. What people are often worried about is that they're currently getting harassed by creditors, not able to answer their phone, or if they're about to default for the first time, oftentimes that's when people are really afraid of what's going to happen when they start calling me off the hook or, text messaging, email, all the collection efforts.
Hello, this is attorney Jamie Miller, and I'm excited to welcome you to another edition of the Miller Law Chronicles Podcast. Today, we are very lucky to have our special guest, Scott Johnson. Hey, Scott, how are you?
I'm doing well, Jamie. How are you doing?
I'm doing good, having a good day. It's November in Wisconsin, and we got our first snow. We got like 4 inches of snow, so that was a lot of fun.
Yep, we're in California and having our first rain.
Yeah, I know. So my wife and I got a puppy a few months ago, and this was his first experience with snow. So it was definitely fun to see that this morning. Traffic was terrible. So people are wondering, hey, I'm talking to Scott Johnson. He is a lawyer with Gale, Angelo, and Johnson in California. And people are saying, why am I talking to Scott? Well, we're going to get into that. Today, we're going to talk about an amazing service that we at Miller & Miller offer our clients in partnership with Scott and his firm. It's essentially, in brief terms, how we help clients once they retain us to prevent creditors from bothering them up until the time that they're able to get to file the bankruptcy. So from our internal way we do things, we know that a client may retain us today, but we may not get their case filed for 60 or 90 days because of various different reasons. So what Scott and his team does on the front end before someone files in bankruptcy is essentially helps us to put our clients in a position where there's not as much stress from the creditors during that waiting period. So we're going to talk about that. And then the other area that Scott and his firm help us with is with helping people understand what their credit report should look like after a bankruptcy is filed. So just kind of wanted to outline the path of where we are and what we do and talk to Scott, who's going to kind of walk us through the process. But Scott, I understand you're a bankruptcy lawyer in California. Tell me a little bit about your background, who you are.
Yeah, so like you said, we're in California. I've been practicing as part of this firm for a little over 6 years now. I've been a bankruptcy attorney for about 13 years now. I'm working, much like you, primarily with people in Chapter 7 and Chapter 13 cases. So that's, I think, the foundation of our practice is really our bankruptcy practice and the understanding of what a bankruptcy client is going through and what they need, and also what is available to them to take advantage of, the full benefit of the bankruptcy process, not just filing the case and getting a discharge.
Got it. And you grew up in California? Is that?
Yeah, so I'm originally from San Jose in the Bay Area, and started practicing law there in the Bay Area. Now we're up in Sacramento, and our office is here in Roseville. I've been here for the last 6 years as well.
The thing I talk to people that live in your area is, are you a Sacramento Kings fan? Or are you a Golden State fan? Where do you fit there? Or not a basketball fan?
Yeah, I'm a fair weather fan.
Okay.
So, here we have, I live somewhat close to the arena where the Kings play. And so anytime that they win, there's a big purple beam that goes up that you can see from miles and miles away. So that's about as good of a relationship as I have to our local teams. Used to go to a lot of Giants games, but now that I'm a little bit farther away, it's harder to
Right.
get.
Yeah. So just speak up just a little bit more so people can hear it, which is awesome. But so when a client hires us, we generally will put them on a payment plan. They may put $100 or a couple $100 down towards the filing of a Chapter 7 or Chapter 13 bankruptcy. And the first thing that we do with the client, other than explain our process, is we make an immediate referral to your firm. And tell me a little bit about why we do that and what you guys do to help our clients.
Right. So the main reason, like you were saying, is if a client is retained, decided to file a bankruptcy case, maybe put their $100 down, but it's going to take, 60, 90 days, maybe longer to actually get everything paid up and the petition prepared to be filed. What people are often worried about is either they're currently getting harassed by creditors, not able to answer their phone, or if they're about to default for the first time, oftentimes that's when people are really afraid of what's going to happen when they start calling me off the hook or, you know, text messaging, email, all the collection efforts. So our process and what I think actually your team is booking appointments with our staff here for us to pull a credit report for the client, go over their list of creditors, identify who's calling them, who they're getting contact from, making sure that we have a complete picture of who their creditors are. And then what we're doing is sending out notices to those creditors, letting them know that they've hired you, that they have counsel, and to the fullest extent possible under both federal and state laws, trying to limit the contact that those creditors make to them while the client's working on getting their bankruptcy case filed.
And so if a client has, they come to us, Discover is collecting, they're getting calls all the time. What can we, as their lawyer, represent to the client that these letters that you're going to send to Discover, for instance, what's going to happen there?
Right. So there are a handful of laws that protect consumers who are behind on their debt or, are subject to debt collection. So one of those, for example, someone like Discover or a creditor like Discover, the creditor can't use any improper means to collect, so they can't be, calling the client multiple times a day at odd hours, trying to contact, people other than the debtor themselves, other than the client themselves, trying to get a whole bunch of information or telling them about their debts. So that's one facet of it. The other part is part of what our notices do is limit the type of calls that people can get. And under the TCPA, the Telephone Consumer Protection Act, people should not be getting those obnoxious robocalls, the pre-recorded messages that creditors so often use, trying to, prompt someone to pay a debt, or, oftentimes what those calls will be is, hang on for the next representative and then putting them in touch with the debt collector. So it should really be limiting those phone calls. And then, other collection efforts like that might be a little bit above and beyond just a phone call.
Right. So we're not saying that the phone calls will stop necessarily. We're saying that the level of harassment will stop.
Right. I mean, so in the situation for someone like Discover is a big bank. They don't necessarily have a whole host of people who are calling thousands and thousands of consumers a day. So someone at Discover can still pick up the phone and call a client under the law until their bankruptcy case is filed. But the robocalls, those pre-recorded messages that are so frequently used, those we can curtail. And then
So
also be on the lookout for things like, if someone's getting 40 calls a day from Discover, that's actionable. That's a problem.
what are you telling the clients and our clients, and what should we be telling our clients to do if those harassing calls continue or if those robocalls continue?
Right. So after we've sent out notices for the clients, we'll reach out, give the creditors about 10 days to receive and process those notices. And we'll just reach out to confirm that type of contact has stopped. So certainly at that point, if those calls are still coming, if the harassment is still continuing, they can engage with us about, how to stop that, maybe get some additional notices out. If there is a violation of the law, it's something that we can potentially look into, filing a lawsuit over. But certainly if someone, that we've sent notices for, and then maybe a month or two down the road starts to get phone calls or have that happen to them, then they can be sent over to us for us to, make sure that if we did send a notice that it got there, and if it did get there, that, we can do something about it, either sending additional notices or filing a lawsuit.
And when we've scheduled or a client is scheduled a call with you, what should the client be prepared to provide you during that call?
Yeah, that's a great question. So it should be a pretty straightforward phone call. All we're going to do is pull a credit report. So we'll need basic information that a client's going to have handy: birth date, social, address. We'll run through the credit report with them. So most major banks and other credit issuers are going to appear on a credit report. There are some personal loan companies and payday loan companies that don't. So if a client is familiar with what's on their report and they know something that isn't on there, that's something that we're going to want to have, the name and an account number for that creditor so that we can send something out to them. So really those types of, some medical debts. There are some personal loan companies, those payday loan companies, that don't typically report on a credit report. Just like they're going to need to provide you that information when they go to file the bankruptcy case, we'll want to get that information as well.
Right. And are there creditors that you won't send notices to?
Yeah, so there's a handful of different scenarios where we either wouldn't send notices or specific creditors who we wouldn't send notices to. So certainly, if you've got a car that you're making payments on, if you own your home and you're making mortgage payments, we're not going to send any notices to those types of creditors because we don't want to get in the way of that relationship, certainly if you're planning on keeping your car and keeping your home. For cars, there might be a situation where someone's about to surrender a vehicle or, wanting to get rid of a vehicle as part of a bankruptcy case if it's really underwater or they're just not able to handle it. So in that type of situation, we would send out a notice. Other types of creditors certainly would be taxing agencies, because unfortunately there's not a whole lot we can do for them before the bankruptcy case is filed. And then in some situations, medical debts. And the main reason for that, it kind of depends on who's actually doing the collecting for the medical debt. But if it's your local doctor or someone that you have an active provider relationship for, even though when you file the bankruptcy case, you can include that shouldn't disrupt their care at all. The way that our notice is worded and kind of the purpose of it is to, limit the contact that creditor and the client have. And that's not something that we want to do when there's an active, doctor-patient relationship at the center of it. Now, the other side of that would be if there's a big hospital group or a collection company that's collecting for a medical debt, we'll certainly send for something like that.
Is there a difference in how you handle like primary creditors like Discover versus collection agencies? Is there a difference there?
There is a different, we will send notices to both of those creditors. There's a substantive difference about what the law requires of them. So the Federal Fair Debt Collection Practices Act, FDCPA, which I think a lot of people have probably heard about. Anyone who gets a bill and sees the little, this is an attempt to collect a debt, that is because of the FDCPA. And that applies to debt collectors. So it doesn't apply to original creditors. It's not going to apply to your Bank of America or Citibank or creditors like that. But any of the collection companies or law firms that are collecting on behalf of the original creditor, the FDCPA is going to really limit what types of collection activity those creditors can take. And the purpose of our notice when it's geared towards a collection company is to essentially stop all contacts. So once those creditors have noticed that the client is represented by an attorney with respect to that account, pretty much all collection activity should stop. There's one letter that they're required to send that basically asks them to, gives them the opportunity to dispute a debt. But other than that, pretty much all collection activity should stop for debt collectors after our notices are sent.
And so client has that initial conversation with you, you review the bills, you send out the notices, you instruct the client to, kind of track those follow-up calls. So how is the client communicating back to you if they continue to get follow-up calls?
Yeah, and that's where we work with the client kind of in whatever capacity they're most comfortable in. So if they prefer a conversation with us over the phone, that's how we can follow up. Certainly with email, with text messages, any way that the client's able to communicate with us. After those notices have gone out, if there is something actionable, if there is a creditor that is just blatantly violating the law and not processing the notice that we sent out, then that's where we'd get additional information like proof of the calls, screenshots, call logs, those types of things.
Okay. And so after that initial conversation with your team, the client will be given contact information and how to follow up with you.
Absolutely. And we'll continue to follow up. So we periodically will check in just to make sure that even if calls had stopped or if calls, oftentimes for that client who is deciding to file for bankruptcy but is current on their debt at that point and you've instructed them to stop paying their creditors, I wouldn't expect that 10 days after that calls are going to start because we're not even in that 30-day cycle. So that's where checking in with someone a month, 2 months, 3 months down the road, just to make sure that no contact is happening, is part of our process and, where we try and check in with the clients.
And if, the client continues to get those harassing phone calls or robocalls or letters, your team is prepared to take legal action against those creditors if there's a violation. And tell me a little bit about, I think, TCPA and how clients, what that means and how clients and how you can pursue litigation under that law.
Yeah, so each law has different remedies available or different ways that a client can be compensated under the law. So starting with something like the FDCPA or the Wisconsin Consumer Act, there's, I believe, a statutory damage of $1,000 that someone can be entitled to. Certainly, if someone's been harassed and they've incurred some emotional stress damages or things like that, those would be recoverable. But in a normal case where there's just contact that continues when it shouldn't be, the law provides for a minimum amount. So typically a couple $100s. Under the TCPA, that is actually for every single call, there's a dollar amount that can be attributed to that. Whether you actually recover that amount is part of the litigation process, but that's where there can be a difference for someone who's received 10 calls versus someone who's received 100 calls.
And it's for us, the benefit of this relationship is really to give clients peace of mind before they actually get their case filed. But it's also the benefit to the client that you're going to be there to protect their legal rights in the event the violations continue.
Exactly.
And so what's weird is I know you bring a lot of these actions. You would think that the creditors would learn. Like, how is it after, the hundreds of actions you probably brought or more, that there's still causes of actions that are out there? It just doesn't make sense to me.
Yeah,
Maybe not you either.
my assumption is that it's the cost of doing business for some entities. There's always, I think in debt collection, there's always a line and they're always right at it. And there are going to be either certain organizations, at individuals, at organizations that cross the line. And that's where, like you said, 99% of the notices that we sent get processed, they're respected. Your clients get a little bit of peace of mind while they're working on filing their bankruptcy case. And for the handful, really, who don't, that's where we're able to come in and enforce their rights under federal and state laws.
Right. And if you do choose to pursue legal action on behalf of the client, there's no fee up front for the client. There's a conversation that you'll have with the client that kind of talks about what the litigation will look like. But bottom line is it's part of the service that you provide, and that if there is a recovery, attorney's fees for your end are taken out of the recovery. Plus, there's a financial recovery potentially for the client as well, with no risk of any out-of-pocket money, essentially.
Right, absolutely. And part of it, and we'll talk about this more once we get to the credit reporting side as well. But most consumer protection laws are written in a way that one of the components of damages that a creditor has to pay for when they violated the law is the attorney's fees, so that the consumer is not out of pocket for those. So I can pretty categorically say we've never had to charge a client out of pocket for any of these cases. They are paid for by the creditors.
Okay. So that's a great, introduction in what we can do to help people pre-filing. And then post-filing, and you do a fair number of bankruptcy filings as well. And we always get these questions. Number one, if I file bankruptcy, how's it going to impact my credit? And number two, what can you do to help me after a bankruptcy is completed or after I get a discharge to help me get back on my feet credit-wise? And one of the things that I enjoy most about our relationship is that there's a lot of lawyers out there whose primary goal, get the bankruptcy filed, get the discharge, and don't deal with helping the client to rebuild their credit after filing. And tell me a little bit about how you help our clients once they get that discharge, what your process is for that.
Right. So after a discharge has been entered in either a Chapter 13 or a Chapter 7 case, pretty shortly thereafter, we'll start reaching out to the clients to ask to get copies of their credit reports. And this is looking at each of the three major bureaus separately, so Equifax, Experian, and TransUnion, to get those reports after the discharge has been entered and review those to make sure that everything has been properly updated, making sure that there aren't still balances showing, that some things aren't showing in collections, that there's not past due amounts, that their creditors aren't continuing to report someone late every single month after the bankruptcy case is filed and after the discharge is entered. Those would be, the main items that we're looking for. And then certainly with respect to secured debt, so mortgages that people are continuing to pay on, cars that people are continuing to pay on, debts that they might have reaffirmed as part of the bankruptcy process, we're wanting to make sure that those are reporting consistent with the law. And that's a twofold part, which is one, to make sure there aren't, the goal of that is to make sure that the credit reports are accurate. And so that's to make sure that there isn't anything out there that's on the report that's hurting the client. It's also making sure that there isn't something that should be on the report that's not being reported that would be helping the client.
So if someone files bankruptcy and they get their discharge and they don't go through this process and they have a debt with, again, we'll just pull out Discover. They have a debt with Discover and Discover is still reporting late on their credit report. They have their bankruptcy discharge. And let's say they go to apply for a car loan a year after. What impact is that Discover reporting late on their credit going to have on their credit a year later?
I mean, that's potentially huge because probably have something that's reporting as past due, reporting in collections, reporting as late. There might be late payments that are reporting. So for someone who's going to, apply for new debt, especially something like a vehicle, something on the report like that could be the difference between being approved for that loan or not being approved, or more likely it might be being approved for the rate that they're advertising in the dealership window versus, say 5%, 6%, versus the 20% or 25% that might be given to people that have issues like that on their credit report. So it really can be, at the end of the day, for something like a car loan, cost the client thousands of dollars.
And if I didn't go through your process and a year later I discover that Discover is reporting late on my credit report, is there an action you can take then, or is it too late?
No, absolutely. Anytime, at any point, obviously we'd like to catch it early, but, at any point, if one of your clients realizes that there's something wrong on their credit report, or if they're applying for that car loan, applying for a home loan, and realizing that there's something on their credit report, especially as it relates to the bankruptcy or for something that should have been dealt with in the bankruptcy, and that whatever is on their report is keeping them from getting that home loan or that car loan, that's a great time to reach out to you, reach out to us, and have us get involved, because there's certainly something that we can do in those situations.
And is Discover culpable for any more damages because that year went by? Or do the damages stem from when you send out notice to Discover, please clean this up, and then they don't clean it up?
Right. So the law that protects consumers with respect to their credit reports is called the Fair Credit Reporting Act. And generally speaking, what that law prohibits, or what gives rise to a cause of action where one of the clients could sue the creditor or the credit bureau, would be if there's something wrong and that's disputed. If the creditor doesn't do anything in response to that, or doesn't make the report look the way that it should, at that point is when you have a cause of action. But I will say, just like with the consumer protection laws that protect against creditor harassment prior to a case file, the Fair Credit Reporting Act does provide for up to $1,000 of statutory damages. So, even a client who maybe hasn't been denied credit, but knows, has something on their credit report that's impacting their credit score, maybe even their perception of what credit they're able to apply for, that person has that, at least those statutory damages available. Certainly if someone's at the point where they're applying for a home loan and they lose out on a rate lock at some good rate and have to pay something higher, those are much more substantial damages that the law would allow, that person to recover as well.
And it's time is so important. And when someone files bankruptcy, it's a big decision to make. And if you're in a Chapter 7, you're in it for 90 days, you discharge your debts. And then, at the end of those 90 days, what's your goal? My goal is to be able to get, a 720 credit score so I can get conventional interest rate on a home or on a car. And, people think that just because they got their discharge, that they're going to be on a path of improving their credit. But the reality of it is that they need to advocate, our clients need to advocate for themselves in order to double check that credit. So to make sure that their credit report is correct and reflects that appropriately for the bankruptcy, so that their credit score can start climbing.
Yeah, absolutely.
And if you just, work with your firm, Scott, and you go through this credit cleaning process and you stay up on your bills as they come due, you stay employed, and making no promises, but what can a client expect after bankruptcy as far as their credit report or credit score climbing, as long as they clean up their credit report after the bankruptcy's discharged?
Yeah, so I think, and this is where our review is helpful. Also good to point out that there's no cost for this process as well. But a client coming out of a bankruptcy case, let's say they had $20,000, $30,000, $40,000 of credit card debt. Going into that bankruptcy case, their credit score, even if they were current on their debt, was probably really impacted by the fact that they're using close to 100% of their available credit, that there might be late payments, there might be past due balances. And all of that is really, each of those components is the bulk of what your credit score is, but it's also really weighing the credit score down. So coming out of the bankruptcy case, we should really be seeing those things minimized. So obviously there's going to be a bankruptcy on the report, and that's going to appear there for a while. But that section of the credit report, the public records, typically accounts for between 10 to 15%, depending on what type of score you're looking at. And the farther away it gets, the less important it is. So coming out of bankruptcy, what you should see is really that fresh start, that clean slate, where you don't have balances showing. You can maybe open a small secured card or get a small credit card and be able to build your credit that way and say pay the card off every billing cycle. And that's what sets someone up within a very short period of time, a year or two, to have that 720 or higher credit score.
And how long after their discharge would you want to have that conversation? So how long does it take the creditor to make sure, the credit bureau to make sure that the credit properly reflects the bankruptcy discharge?
Yeah, so we'll typically reach out and ideally would be pulling the credit report within about 3 to 5 weeks of once the discharge is entered, because that gives, most creditors update things on a monthly cycle. It's not necessarily instantaneous, so that would allow pretty much everyone who's on the report to do the updating that they need to do, and we'd know at that point, who isn't following through, who hasn't updated the account properly. And that might be on the creditor side, that might also be the individual bureaus that are not making sure that the information is accurate.
So if the information's not accurate, you send out notice to the creditor. Do you send those out or do you have the client send it out?
So we assist the client in disputing those and then can make sure that all the information is there. In some situations, it might require, for example, if you're making your car payments or your mortgage payments, we might need a bank statement or an account statement that proves those payments. But we get those disputes sent out to the credit bureaus. They have a little over a month to make sure to process those disputes, to allow the creditors to update everything. And at that point, for anyone that had any issues on their credit report, typically about a month after those disputes go out, we'll pull a second credit report and make sure that everything's been updated.
And if it's not updated, you're able to bring a claim under the Fair Credit Reporting Act, correct?
Right. So at that point, there would be a cause of action against either the bureau or the the creditor who's doing the reporting under the Fair Credit Reporting Act.
And the client doesn't need to fear in this situation that there's additional fees to them. If there is a recovery, your fees are paid out of the recovery, and then any damages that would go to the client would come to the client, but there's no risk of anything out of pocket to the client.
Right, absolutely. And the Fair Credit Reporting Act is one of those laws that requires that if there is a creditor or anyone who's done something wrong under the law, that in addition to that, up to $1,000 that the client might be entitled to, any attorney's fees are paid for by the creditor as well. So there's nothing out of pocket.
Right. So the service is remarkable because, it's really giving the clients, a leg up after they file for bankruptcy and get their discharge. And we can do this for Chapter 7 or Chapter 13 to really help them improve their credit. And the one thing, and you probably do the same thing with your clients, Scott, is I always tell the clients that, listen, when we file bankruptcy for you, we're going to work with you to help you get that improved credit score. But it's not something that happens automatically after the bankruptcy's done. We create the opportunities and we'll collaborate with the client to help improve the credit score. But they have to understand that it's a partnership and that we'll work with them. And if they file the steps, if they meet with you after the discharge, if they continue to communicate with you about their credit report, if they do our 7 Steps to 720 program, the chances of them getting a 720 credit score after filing a certain period of time is really good, but it's not guaranteed. It's something we need to work together with our clients to achieve. And I'm grateful to you, Scott, and your team for everything that you do to help our clients pre-filing, to keep their creditors off their back until we file. And even more important is how much money we're able to save our clients post-filing with interest rates and those things, as long as they're able to go through the program and with you and help clean up their credit post-filing.
Right, absolutely. And I would say, one other thing that we oftentimes will hear from clients when we reach out to them to do our post-filing service is that client who says, I don't want to touch a credit card ever again.
Right.
I don't care. I don't want to go through this process. And what I would say to them is this process might be even more important for you because even if you never want to touch a credit card again, you might need to buy a car, you might need to buy a house, you might need to replace a heater or an air conditioning unit and finance that. And what's on your credit report then a year, 2, 5 years down the road is really important, and we can do something to fix it out of the gate.
Okay, you're the best. Thank you so much. I appreciate your time and the
Absolutely.
valuable information that you shared with me and with our clients. And have a great day. And we will
Thank you.
look forward to talking to you soon. Thank you so much, Scott.
Very good. Thanks, Jimmy.